topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Florida. Welcome to another Ask the Expert show, where we bring you the finest experts in the areas of legal, health, financial, and home improvement. Today is K. Bender Rimbaum Day. Listen, this is still, with all of our markets across the country, it is our number one show for South Florida, for Tampa, Orlando, Palm Beach. And we appreciate all the questions that you send in to us. You can reach us today if you've got a question. Many ways to do this. You can either call us at 561-623-9429. This is if you have a question for attorney Alan Swartzide. He is an attorney with K. Bender Rimbaum. We're talking about community association law today, HOA, condo, so many things happening. We also have a chat center. If you're watching on TV, you can actually write a question in. And again, we'll be more than happy to answer that for you. Let me welcome you, superstar attorney Alan Swartzide.
Hi there. You know, this is the first time I've been described exactly the way that you described me today. I think it was the fantastic expert or something like that. I don't think I've heard the specific phrase you used before, so thanks.
Well, you are. And, you know, listen, people love, you just started with us this year, and people love the way you do the show. And we've got so much today. I've got so many questions. But first of all, since we get so many new people tuning in every week, please tell everybody about K. Bender Rimbaum.
Sure. Well, we're a law firm that has almost exclusively or exclusively altogether represented community associations. So that's condos, HOAs, co-ops. Since the 1990s, we've got 21 attorneys, 8 of whom are board certified in this area of law. We also have one of those 21 is board certified in construction law. So really any issue that comes up in a community association, that's what we handle on a day-to-day basis. And it's pretty much all we do. I think it's important when you're dealing with a condo and HOA or any of those types of communities that you have someone that really only deals with those issues, or at least does a majority of their work in those fields. I see a lot of people that are just hiring real estate attorneys thinking they're going to do a great job because they have a lower rate. And I can almost promise you that lower rate, you get what you pay for, and you'll end up paying more to fix the problems that they cause because of the very specific procedures, statutes, and frankly, the case law that most of those people just won't know about that our firm deals with every day. So, you know, obviously welcome anyone to reach out if your community needs some help. If you're not happy with your current counsel, we do literally nothing else all day long for the last 30, 40 years. So again, K. Bender Rimbaum, it's really just, I've been back with the firm a little over a year. I was with them from 2010 to 14, and there's nowhere else that I think I'd be as comfortable or that would treat its clients better. You know, I think the biggest distinction between us and a lot of other firms, regardless of anything else, although there are a ton of other things that distinguish us, is just the fact that you're going to hear back from our attorneys within 24 hours. I hear so many people saying, hey, you know what? I reached out to my attorney 3 weeks ago, haven't gotten an answer. They send me a text. I send them the answer back because I don't have to look at their documents. and it's done. So they've gotten the answer from someone who's not getting paid for it quicker than their actual attorney. And that's honestly, I hate to say it, but that's how a lot of our clients end up with us, is just our willingness to be available to people, especially during
Customer services,
and classes.
customer service is very important to your firm.
Yeah, agreed. I mean, frankly, I think the expertise is certainly important, but the accessibility is something that, regardless of how smart your lawyer is, regardless of how much they know, regardless of how great a job they do, if you can't get a hold of them when you need them, what do you need them for?
Hey, let's go to our first phone call. Let's go to Suzanne in Tampa.
That was quick.
Yeah. Hey, Suzanne. Suzanne, are you there?
Me?
Well, maybe it wasn't as quick as I thought.
Yeah. No, maybe she can't hear. Maybe she didn't think she was going to come on so fast. Suzanne?
Can you hear me?
Yeah.
Wow.
Yeah, we can hear you.
Okay. I'm calling about the state fire prevention code and wondering if you can give us any information on any statutory update. We understand that the deadline for the retrofitting or the ELSS is currently January 1 of 2024, but we understood that the state fire marshal could approve a new deadline, which what was recommended by the Florida Safety Advisory Council would extend it to January 1st of 2027. Do you know anything about any changes in the deadlines?
I know there were changes, and candidly, I don't recall offhand what it is. So I'm going to be just honest, just like I always try to be. I'm trying to look it up right now while you're on the line. But I know there was a change this year. I don't recall exactly what the deadline ended up being, but it would not surprise me if it was extended out that far. And everything I'm finding, frankly, doesn't help. What I can suggest, rather than waste your time, is that you check out our website at kvrlegal.com and go to Rembaum's Roundup. It's a great newsletter. He's got a fantastic legal update that covers every single statutory change that was made this year. And I believe that change is included in that. I think it's a 10, 15-page article. So that is probably the easiest way to get the answer. Alternatively, you're welcome to email me. It's as@kbrlegal.com, and I'll be happy to get you the answer within the next day or two.
That would be wonderful. Thank you so much. I will check out the website and see what I can find, and that would be such helpful information. Thank you so much for taking the call.
Thanks,
you're very
Suzanne.
welcome.
Hey, you know what? You just never know what kind of questions that listeners and callers you're going to have. And there's, Alan, there's so many changes always going on. There is so much to know as a board member, and how any board member can even try to handle this all without a firm like K. Bender Rimbaum.
Well, the bottom line is they shouldn't. And that's why firms like ours exist. That's why, frankly, we find education to be such an important thing. I mean, you're seeing at the bottom of the screen, we've got all these seminars and webinars coming up. One of them is a legal update that my partner, Mike Bender, is going to be giving on November 1st. And that's where you'll hear about all these statutory changes. So anyone that's looking for more guidance on that, in addition to the Rembaum's Roundup that I just suggested checking out, I would absolutely listen and observe and attend Mike Bender's class on November 1st. It's 2 to 4 p.m. via Zoom. Bottom line, back to what you were saying, Steve, I don't think any director should know as much as we're expected to know. And frankly, I don't think the attorneys in this field know as much as they should know, including me. That's why a lot of times I still look stuff up, because I don't want to give an inaccurate opinion as to what the law requires of the communities that I work with. But I do think it's extremely important to get educated so that you at least have the basics to know when you should be asking the attorney those questions.
Exactly. And I've told you this before. I deal with a lot of law firms across the country because we're in 12 markets now. And I got to tell you, you would not believe how many law firms just throw up, HOA, community association law to their long list of areas their boutique handles. Whereas K. Bender Rimbaum, I would say mostly what you do is community association law.
I would actually clarify more and say it's almost exclusively. There's very little other work that we do. And frankly, all of the other work that we do is directly related to community association law.
Correct. That's why it's so important with a firm like yours that it is to have a firm that basically concentrates in one area. It makes a difference. I've seen that across the country. So when you're doing your due diligence and you need a community association law firm, and I'm not trying to make this a commercial, but you offer so much at K. Bender Rimbaum. I mean, just doing this show, you all have been doing this show for 10 years, and it used to be an hour each month. Now you take 3 hours each month to do this show. And it just shows that you want to educate people. And that's exactly what you do. You guys are the best.
Well, I mean, I appreciate that. Candidly, an educated client is one that knows what questions to ask rather than having to dance around it. And it ends up where that education tends to actually save money, even though the association's coming to the attorney and asking questions, because you're able to ask them more intelligently. There's less of the attorney having to ask questions to try and figure out what's even being asked. And I could spend 15 minutes talking about this, but I'm not going to bore everyone with it. I know we're here to answer questions, but the bottom line is we just think education is one of the most important aspects of this industry, so that the people that are volunteering their time, just like we are, but they're volunteering it with really no thanks, whereas eventually we might get paid for our services. They're volunteering their time and saying, I think it's important enough to make sure that my community, where presumably I live, or at least I own property, is going to be properly maintained and operated. If you're going to show that caring to say, I'm going to get on the board and do this the right way, we want to make sure that you have the tools that you need to do it the right way. And that's why we provide all this education.
Hey, Ellen, being on the board versus being the president of the association, is there a lot more work to do as the president versus just being one of the board members?
Well, I mean, there are two completely different concepts, and I'm glad you brought that up because, frankly, most people seem to think I hear people talking about the board president. Well, the board, the directors, and the president, the officers, are two completely separate concepts. They don't even have to be the same people. So the directors are the ones that get to make the motions, vote on motions, and second motions that the members don't get to vote on as a general proposition. So the decision of what's the budget going to look like, things like that. Do we want to assess for this or that? Those are the types of things that the board gets to vote on. So when you ask, is that something that, the president does more or less than the board? Literally, the only thing the board does is vote on motions, make motions, and discuss what's being voted on. The president has specific obligations under whatever the bylaws are that person, or potentially the articles of incorporation, that say these are the things the president's supposed to be doing. It's basically being the mouthpiece of the association, signing the contracts. And frankly, whether one has more obligations than the other just depends on how your community operates. So I can't say definitively yes or no. I know that's a very lawyerly answer, but the answer is it depends. If your community has a manager who does the bulk of the work that the officers would normally be tasked with, then clearly the president's going to have less obligations and the directors are going to be doing more than the president. But if you're a self-managed community, usually the president is the one that takes on the bulk of the work. And just to be clear, self-managed is acceptable in Florida. It's not necessarily something I'd recommend because, frankly, having a manager there just makes things easier. It's someone that is a professional that is trained to do the job that you're doing as a volunteer and can get personally sued for if you screw it up. So the likelihood that spending the money just to have the manager be the one that is not making the decisions, that's still the board, but is taking on the role of the treasurer, taking on the role of the secretary for the most part, is really helpful.
Is elections coming up? I noticed a lot of the questions were about elections this time.
They are. It's definitely election season. Budget season usually coincides with election season, and they're both going on right now. So if you're talking to property managers, this is going to be the time that it's hardest to reach them because it's budget season. They've got meeting notices going out constantly for the budgeting, the election, etc. But yes, the short answer is definitely election season through pretty much January.
Okay. Now, I'm going to go to our text. We have a text from Brad in Tampa. He wants to know, can anyone run for the board? Do they have to be an owner?
So those are two different answers. Do they have to be an owner? Depends on the governing documents. They might say you have to be an owner. They may say you don't. So you're going to probably look at your bylaws or your articles of incorporation to make that determination. It's not something that's statutorily mandated. Now, when you ask, can anyone be on the board? The answer is yes, with limited exceptions. So if someone has been convicted of a felony and hasn't had their civil rights restored for 5 years, they can't serve on the board. If someone is delinquent in payment of monetary obligations to the association, they probably can't be on the board. In condos, it's a little different than HOAs. I don't need to get into specifics, but there are certain criteria, and in HOAs, there's actually more criteria now than there were last year. That's one of those statutory changes as to who can serve and who can't. The general rule is anyone can serve, but the more specific rule is except with these limitations that are set out in the statute. There may be other limitations set out in your governing documents. I very rarely see those. It's usually just what's in the statute, but you'll want to look at both. And frankly, you'll want to get a legal opinion to protect the association and the individual directors who are deciding who gets listed on the ballot and who doesn't. You'll want to get that opinion to protect those people from any claims that this was some kind of vindictive act or something like that, to not list someone on the ballot that should have been listed or allegedly should have been listed. So that's a lot of words to say it depends.
Right. Let's go to Barbara in St. Pete. Our bylaws state that directors can be removed if they are no longer a member. Is this true?
I mean, if your bylaws say it, then is it true? Yes. Whether it's enforceable might be a different story. Because the Florida statutes provide a procedure for removing directors. They should be stepping down if they no longer own property in the community. If your bylaws also say you must be an owner in the community to serve on the board, then that would probably trump the statute, in my opinion. But if it's just, well, they moved out, unless your bylaws, you're telling me your bylaws say that they need to step down or they are removed when they move out, they no longer own property in the community. There is a recall procedure if that person doesn't step down and agree that they're no longer on the board. So chances are, yes, that would be enforceable, but I can't say definitively. It's going to depend on certain language in your governing documents and whether the statute or your governing documents control. So that's unfortunately yet another case-by-case analysis for the most part.
Ellen, what about renters? Can renters be on the board?
Again, depends what's in the governing documents. If they say you must be an owner, then the answer is no. If they don't say that, or if they say that tenants or co-residents who are not owners are allowed to serve on the board, then the answer is yes, they can serve. But if it says only owners can serve, the answer is no. Even if they have some kind of, power of attorney or something of that nature, they're not going to be allowed to serve, even if there's no one else that wants to serve on the board.
So, Ellen, if you're representing a client, and do they ask you what's your opinion? Should we have a law for this? Should this be in our bylaws? Do they ask you to help them in that area?
Only the smart ones. That is something that, so we have a little bit of separation within the firm, and that is something that I personally work on daily, is those types of amendments to the governing documents, whether that's the declaration, the covenants, rules and regulations, architectural criteria, bylaws, whatever that may be that they want to change. they should be running that by their attorney if they're making changes to their governing documents, because there's a lot that's not in the statute. And even if you're a lawyer that's, let's say I have one client who's got a New Jersey lawyer on the board, and this gentleman is smart enough to say, I'm a lawyer in New Jersey. I do family law. I don't do community association law, and I'm not barred in Florida. So I understand, like a lot of these real estate attorneys and other attorneys that don't really practice in this area might not understand, that it's not just the statutes you have to look at. It's also the case law that says what you can and can't have in your governing documents. It's also the Fair Housing Act and other Americans with Disabilities Act. Basically, you want to make sure that your attorney who's well-versed in community association law is looking this stuff over before you make any changes, to make sure that what you're putting in there is actually going to be enforceable. Because if it's not, then what are you even wasting your time for?
We're going to go to our first break. We've got text from Dina and Barry, which we'll ask as soon as we get back. So hang tight there. Alan, give everybody your phone number.
Sure. The one that will reach literally any of our 4 offices, which are Orlando, Tampa, Palm Beach Gardens, and Pompano Beach, is 954-928-0680.
And that website again?
KBR, which is K Bender Rembam, KBRlegal.com.
Okay. We're going to go to break. When we come back, we have more with Ask the Experts and K Bender Rembam. We'll be right back.
K Bender Rembam is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On KBRlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K Bender Rembam attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K Bender Rembam is also a well-known provider of free legal education for managers and board members. Contact K Bender Rembam today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show, and we are with you every week. We have got one of our finest experts on. This is our legal day, K Bender Rembam. We have attorney Alan Swartzide, and wow, we just got a board full of calls. Hey, let's go to, this is from Dina, that it appears the statute, you can see it right there, on ELSS, not yet amended, just past January 1st. However, local authorities might extend the deadline for a condo.
I'm going to give the exact same answer I gave on this exact same issue earlier, that I would have to get back to you because, frankly, I don't know offhand what the current deadline is, because it's just not an issue that I've personally dealt with frequently. But I anticipate it would take me about 5-10 minutes to look it up. I'm not going to waste everyone's time right now doing that.
Okay. Hey, let's go to this. Here's Barry's text. If an association wants to transfer non-CERS pooled reserve that are listed in paragraph, I guess it's G,
yeah,
non-CERS reserves for the roof and exterior painting to pooled CERS reserves, must the owner approve?
So this is going to be an entirely confusing statement for 90% of the people listening to this show. My short answer is most likely yes. And what we're talking about is the laws that have come out over the last 2 years pertaining to condos in particular, that basically outline certain reserves that need to be maintained no matter what and can't be touched, etc. If the association wants to move those reserves that already exist into literally anything else, including a pool of new reserves for these specific items that are related to the structure of your building. My opinion is if you want to move those anywhere other than to the existing reserve, you need to get a member vote. Pretty straightforward. That's my opinion.
Okay. You know what? You've got a list of classes that you're going to be holding. Can we go through those?
Sure. On the 31st, it's actually me teaching community associations. Should I pay or should I go? It's a collection class. That's going to be on the 31st, next Tuesday from noon to 1:15 on Zoom. I mentioned Mike Bender's legal update coming up on November 1st. November 9th, we've got elections for community associations. So that's going to include HOAs. That's going to be another Zoom at 2 p.m. As of now, it looks like it's Peter Mullengarden of our Palm Beach Gardens office, and that's hosted by GRS Community Management. We've got the importance of updating your governing documents being taught by Kirsten Henza of our Tampa office on November 10th. We've got another legal update by Mike Bender yet again, hosted by Campbell Property Management on November 14th at noon, again via Zoom. We've got HOA board member certification that I'll be teaching on November 28th from noon to 2:15 via Zoom, and condo board certification by Kirsten Henza again, November 30th from 2 to 4:15 on Zoom. So a ton of classes, a ton of Zooming, and hopefully by the end of it, people will have learned some things is the way that I'll put it.
Hey, Ellen, why don't you, there's some people out there probably wondering about if they should run for the board or not. Tell people about the certification classes.
Sure. So I mentioned two of them that we're teaching for condo and HOA next month, and those are important. So the reason they're important is you've got two options when you become a director of a community association. You can either take that class and get your certificate through the class and get educated and understand a little better what it means, what your obligations are, what it means to be a good director, what you need to know, and what you probably need to know but won't know, and what you probably won't remember from that 2.5-hour class. You can either do that, or you can sign a piece of paper that says, I will uphold to the best of my ability all of the requirements of the governing documents in Florida law. Now, here's the problem. Okay, you can read the Florida statutes. That's not going to give you all the information that you'll get in this class. And that also requires that you be able to interpret the Florida statutes. You can read through the entire statute book. You can read through your entire governing document set, but your governing documents conflict and you won't know which one applies. Okay, chances are there's at least one or two conflicting provisions between your declaration, your bylaws, your articles, etc. Chances are there are going to be about 20 to 30 vague provisions in your governing documents, and you're going to need guidance as to how to interpret those. Frankly, what you should be doing is getting your lawyer to interpret them, but you won't necessarily know that by just reading through the governing documents and reading through the statutes. Matter of fact, you're more likely going to be confused more than you'll learn as compared to this class where you will learn. You might not remember it all, but that's why at least our firm, we always provide the materials at the end of the class so that you've got that record available that you can then refer back to. Now, if you choose to sign the certificate, I will still recommend that you go and watch that class online, even if you're not getting credit for it. You know, if you're not watching it live and you can be sitting there at 11 o'clock at night in your underwear with a drink in hand, at least you're getting some of the information from it. And that's all available at kbrlegal.com under the resources tab. We've got all of our past recorded classes available to watch. You just won't get the credit or the certificate for it. But at least you can get the information, you can get the education, and then you can reach out to whoever taught the class afterward if you have additional questions, and they may or may not be willing to respond. I will, but I'm not going to speak for all of the other attorneys within the firm. But I think that class is extremely crucial. And frankly, I know that a couple of my partners agree, and I definitely feel that it should be mandatory instead of just signing a piece of paper. Because if you're not at least getting educated, you might not, as a volunteer director, have literally any experience running a business. And that is what you're doing, whether it's a for-profit business or not, if you're running a community association on the board. So I think it's important so that you don't screw up inadvertently without even knowing you did something wrong, to take that class and learn as much as you can. And take all of our elective classes, like all the other ones I mentioned, the legal update, the collection class. We do a great covenant enforcement class, fair housing class, all of them. Watch them and get the knowledge so that you know what questions to ask when those types of issues come up in your community. But you got to know what to ask the attorney. Otherwise, you're not going to ask the questions, and you're just going to get yourself and your community in trouble.
Speaking about what to ask, I think one of your best classes that I enjoyed, I was there. I was shocked, actually, that you're asked the attorney. That was the most, I guess, educational. I learned a lot, but it was so interesting. I saw a guy sitting there, and he had one question, because you could see on his little bitty piece of paper, that guy ended up asking about 7 other questions. Because you hear people ask other questions that are there, and it was full. There was about 70 people there. And all of a sudden you go, oh, that's right, I want to. And it was the most enjoyable 2 hours. It was unbelievable. I think it's called Ask the Attorney.
Yeah, ask the attorney. It's the typical, you don't know what you don't know until you know what you don't know. And when you attend a class like that is pure question and answer session that talks about all kinds of different topics, which is what we do during the Q&A for the board certification classes. The bottom line is you hear more and more, and all of a sudden it's, oh, but what about this that you didn't talk about? We can't talk about everything during that class. Honestly, I could sit there and do a 40-hour board certification course if I was given the time, but no one wants to take that class. And frankly, I'm not going to do it for free at this point. But I could easily put 30, 40 hours into that class and then do a full day question and answer session if given the time. So, it's amazing how much more you think about when you start to hear people that know what they're talking about this subject matter.
Got you. Ellen, we get so many letters from people that I guess they're handicapped, and they're upset that there is not enough handicap parking. What do you do? I mean, I know it's in your bylaws, but what do you do? How do you get more, I guess, handicap parking?
Well, I mean, the first step is they have to actually ask for it. So if someone if someone's complaining to their neighbor that, well, I can't park, that's not going to help them unless their neighbor happens to be on the board. So the first thing you have to do, whether it's an accommodation of the rules because you have a handicap or a disability, or it's an accommodation of the physical, which is called a reasonable modification of the community, you got to actually ask for it in order to be entitled to it. There are certain procedures that the association is supposed to follow when they get that request. But if they don't get the request, they're not obligated to go out and ask the entire community, hey, does anyone need another handicap spot? So the first step is reach out to your board, reach out to your manager and say, hey, I need a spot to park in, and there's already someone that's always parked in the one handicap spot that's available in the entire community. What can we do to make this work? And then the board needs to go through, the process that's required under federal and Florida law, which is that Fair Housing Act, Americans with Disabilities Act type of situation. But unless someone makes a request, there's nothing the association has to do or can do.
Sounds like you're telling me you've been through this before.
Once or 50 times, yes.
Hey, Al, I got this is another personal question. When we first started the show, there were so many questions about pets. I mean, it was like probably 7-1 questions about pets. We hardly ever get questions about pets anymore. You find that true at the office?
Yeah, I mean, we certainly get them, but I'm finding that less of them are frankly frivolous requests by someone that just wants to have a pet and the restrictions say no. And I think part of that is the law that went into place, I think 2 or 3 years ago, that basically actually had some consequence for fabricating I'll call it a permission slip to have that animal. And keep in mind, when we talk about a service animal and a support animal, those are not considered pets under the law.
Right.
When we're talking about those animals being permitted in the community, the law that went into place that basically made it, I don't recall whether it's a misdemeanor or a civil penalty, but it is actually there is a penalty now that if you falsify that information, if you say someone needs an animal that they don't really need, if you say they have a handicap that they don't really suffer, etc., there are actual penalties for the physician that wrote the letter and the owner. I think once that kicked in, people weren't able to get those doctor's notes anymore or the physician's notes. And so there was less of that going around, so to speak. And frankly, that was the purpose of the law going into effect, was so that the people that need it can still get it because it is an important function. I 100% support the legit causes. But the ones where, someone gets upset when they eat cheese, so they need an animal, I'm sorry. I don't think that's a necessity unless a doctor truly thinks it is. I'm not that kind of doctor, so I can't comment. But my personal opinion, not my legal opinion, would be you probably don't need that service animal, or I'm sorry, that support animal. So unless it's like you are deathly allergic to cheese and that animal serves a purpose to call 911 for you, I don't think you need that animal. And that's the type of, you'll excuse me, but the type of stupidity that was going around until some of these laws went into effect. So I think it's yes, the short answer is yes. I'm seeing a downtick in the amount of those requests being made. And I think it's because now people understand, listen, you are screwing this up for all the people that truly need these types of animals, because community associations and other housing providers are looking at it as, well, we need to be cautious about who we let have this and who we don't, because if we let one person have it, there's the perception that everyone gets it. And that is not the case, but it is the perception within a community.
I just saw where Publix is not allowing animals in the store anymore. That's a big jump for them.
Yeah, I mean, I think it makes sense. I don't know that it necessarily complies with those laws, but I anticipate Publix got a legal opinion before they decided to say you can't have this anymore.
And are they the same for condo and HOA?
Yeah, it pertained to the actual emotional support and service animals in general. Has nothing to do with condo HOA. It's just across the board.
Okay, let's go back to our text. This is an odd question, and I don't even really understand. I don't even understand it. They want it, and listen. This is from Ken in Tampa. I am so glad you sent us a question in, but he wants to know: can condos charge extra for an extra car? Which I understand that, and bike racks. That I don't understand.
For an extra car, you could presumably charge extra, but only if you are designating a space for that car. I don't see what basis you would have to charge for the use of an extra random spot unless your governing documents say you can do it. And even then, I would call it questionable. With respect to the bike rack, unless it is an electric charging bike rack, I don't know what basis you would have to charge for use of a bike rack unless it's, storage or something of that nature. Usually that's an amenity that the association provides, and any one of the people that wants to park a bike on the rack can use it. I I don't know what basis you'd have to charge for use of that amenity.
Yeah, really. Okay. Connie and Brandon, this is a condo question. We're trying to get everybody who writes questions in to let us know if it's a condo or HOA, and we are starting to get people a lot better at that. They have a condo in Broward and in Tampa.
Okay.
In Broward, inspection goes by square footage. And regarding inspections, is that right? For
That's my understanding. Yeah.
For the recertification.
Mm-hmm.
So it's different in Broward Dade than it would be in Tampa.
I mean, South Florida is a whole different animal in pretty much every aspect. So unless it's statutory, they can do whatever they want within the confines of the law. So yes, it is treated very differently in Broward, in Miami-Dade, and to some extent in Palm Beach County versus Tampa, Orlando, or those types of markets.
Well, is everybody going to have the 3-floor require? I mean, they're required to do the inspections.
That's
if they're 3
so
floors or higher.
When you're talking about milestone inspections and structural integrity reserve studies, which is what Barry was asking about earlier, that's statewide. Now, the governing of the oversight of that might be local, depending on the circumstances. It generally will be. But the obligation to do it is statewide. That is separate and apart from Miami-Dade's recertification process, Broward's recertification process. So I don't know offhand what Tampa's process is, but if it's only those structural integrity reserve studies and the milestone inspection reports, then you just might not have separate requirements for Tampa, similar to the recertification requirements in Broward and Miami-Dade.
Let's go to the phone. Let's go to Kent in, Palm Coast.
Yes, I have an HOA question.
Okay, good.
Can I have some of my privileges? Can I have some of my privileges suspended without having a board vote on it?
No.
So, for example, if I was in the pool and it says no diving, but then me or some of my kids were diving, they actually have to have that go before the board to say that I need my privileges suspended, as opposed to being able to just take my key away for some limited amount of time.
Yeah, I mean, they can do it for a limited amount of time, but it's especially for a covenant violation, they still need to have a board meeting. The only thing they might have done without having a board meeting that you were aware of is put a general item on the agenda and vote across the board on, let's say, 20 different lots in the HOA whose rights they were going to suspend in this manner. But generally speaking, they can't do it without having any board meeting whatsoever.
Okay, so there's no way to write the governing documents in such a way that says, if you do this, it'll automatically be suspended for 30 days or something.
Well, the statute requires, in order for them to do that they actually have a board meeting. They could write the governing documents in that way and make the argument that, well, the declaration says we don't have to hold a board meeting, we can just do it. And then they would make the argument in court, presumably, that they've complied with the governing documents. And your response in court would be, but you haven't complied with Florida law. And then a judge makes a decision of who's right and wrong if it gets to that point. My position would likely be that the statutes control, but you know what? I'm going to be candid, and I don't think I've said this on your show yet, Steve, but it's my opinion. Judges are generally elected or appointed lawyers. They may know absolutely nothing about community association law. So it's on you or your attorney to educate those judges on this area of law. So my answer is,
okay.
Bottom line, it could go either way. My personal opinion is that the statute most likely controls, and that the board needed to meet regardless of what's in the governing documents.
Okay, thank you very much.
You're welcome.
Thanks. Sometimes we get text in. I'm going to have Juan put this D in his text up because we've been talking about how important it is for these classes. Totally agree that the courses you and other attorneys give should be mandatory. I have smacked my head repeatedly during board meetings watching board members who have no clue.
Well, and candidly, that's part of the reason that you have to have more than one director in order to have a successful community. I've only seen one community where there was only one director for a couple of years and it was run well. All the other ones where you have less than 3 people, it's just, you have basically dictatorships at that point, and it's not healthy. And frankly, those are usually the ones that choose not to appoint anyone because they don't understand what they're supposed to be doing. So bottom line, Dina, I totally agree with you.
Here's one from Michael in St. Pete. Unit owner has a unit full of mold. New owner is not cooperating. What do we do?
Well, when you say unit, I presume you mean in a condo, which means that chances are
probably.
you are subjecting the rest of the units and the common elements to potential mold problems. And so
Right.
the association has a statutory right to enter that unit, inspect it, find out whether the mold is still there. And chances are, under the governing documents, you probably also have the right to clean out that mold if the owner refuses to do it. So your first step is going to be to send a demand saying, we're going to enter into your unit because we understand there's mold and we need to do an inspection for the protection of the common elements and for the protection of all of the other units surrounding this one. If they refuse, then you might end up having to get what we call a temporary injunction, which is basically going before a judge and trying to get an immediate injunction so that you can enter into that lot or enter into that unit, and clean it out. But the bottom line is leaving that sitting and not taking action is a huge mistake, in my opinion. You have to do something about that because you're putting all of the common elements at risk, and you're basically risking that all of the members are going to pay for the cost to remediate that mold because it starts to impact your common elements, starts to impact other units. I'm dealing with a situation just like that right now down in Broward County. And, we basically had to force our way into the unit, not physically, but you have to send demand letters. I would suggest that you have your attorney look at your governing documents, and anyone that's here that doesn't have an attorney and is hearing what I'm saying, have your attorney look at it. Please feel welcome to reach out because this is what we do day in, day out. But bottom line, have your attorney review the governing documents to see if you have not only that statutory right of entry, but the contractual right under your declaration to go in and fix the problem and charge the cost to the unit owner who's causing it, whether that's the new owner or the former owner. Frankly, doesn't matter. But hopefully the declaration will say that you get to charge that as an assessment against the unit, meaning if you do the work, you end up collecting that as an assessment, you can lien and foreclose for it. If not, still need to do the work even if you can't collect it that way. But you can't just leave that sitting. It's almost violently dangerous to the rest of your community.
Alan, you know what the problem with this show is? It just goes by so fast. And I want to compliment you. Let's give everybody your phone number and your website.
Sure. The number that'll reach any of our offices, it reaches the front desk in Pompano, is 954-928-0680. Our website, where you can find any of the resources I've talked about today, or you can just find where to contact me or any of our other attorneys, is kbrlegal.com. And if you add AS as in Alan Schwartzide before kbrlegal.com and that little @ symbol, you'll also reach me via email. So my email is as@kbrlegal.com.
Well, I got to tell you, we do 20 shows a week. That's the experts. And I got to tell you that this is our #1 watched and listened to show. And it's been like that for years. We appreciate that. I apologize to all the people on hold, all the people who had a text in. I promise we'll get to your text next time when Alan's on. Alan, thanks again. Great show. And we'll see you soon.
All right. Thanks, Steve. Thanks, everyone, for listening.
And we'll be back again next week with more Ask the Experts. Take care, everybody.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.